In 1856, a Louisiana court received a case it could not properly classify. An enslaved woman named Della had, the course of 8 years, poisoned 11 of her own infant children. When the fact was established and the legal proceedings began, the court encountered a structural problem. Under Louisiana slave law, her children were not legally persons. They were property, registered assets belonging to the plantation owner. Killing them was not, by the letter of the law, homicide. The case proceeded anyway, under a different charge, and Della was convicted. The 12th child, the one who survived, was sold within the month. If you believe the law exists to define what is human, this case will force you to reconsider who that definition was written to protect. Subscribe and stay until the final document, because what the court recorded and what it refused to record are not the same thing. Now, let's return to where it began. The plantation was located approximately 14 miles northwest of New Orleans, on the west bank of the Mississippi. It was a sugar operation, mid-sized by Louisiana standards, owned by a man named Prosper Lemaire, who had inherited it from his father in 1831. The property was registered with the parish as holding 43 enslaved persons in 838, the year Della's first child was born. The child was a boy. He was delivered by an older enslaved woman named Josephine, who had performed midwifery on the property for over a decade. The boy was healthy. He was given no name by the household. Della named him privately, in a language no one else on the property spoke, and told no one what the name was. Della worked in the sugar processing house, a low, long building set back from the main residence, where raw cane was boiled down through a series of iron kettles in a process that required continuous monitoring and physical endurance. The work ran in shifts during grinding season, from October through January, often extending past midnight. The heat inside the building during those months was described by one overseer's report as barely tolerable for extended labor. Workers were expected to maintain kettle temperatures within specific ranges, skim impurities at timed intervals, and transfer boiling liquid between vessels on a schedule that allowed no error. Burns were common. Della had a wide scar across her left forearm from a transfer accident in 1836, 2 years before her first join. She had never been taken off the processing rotation for medical recovery. She returned to work 4 days after the accident. The overseer in 1838 was a man named Claude Thibodeau, who kept a labor register organized by worker name, daily assignment, and productivity output. His register also contained a column for what he labeled incidents, a category that included injuries, refusals, absences, and what he described as dispositions requiring correction. Della appeared in the incidents column twice in 1837, both times for slowing her work pace during the final hours of a night shift. The notation read, "Warned, resumed." In 1888, after the birth child, she did not appear in the incidents column for 11 months. The secondary characters in Della's daily life were structured entirely by the labor system. Josephine, the midwife, was in her late 50s and had delivered most of the children born on the property over the previous 15 years. She reported births to Thibodeau, who recorded them in a separate livestock adjacent ledger that Lemaire used to track the growth of his human inventory. A newborn was entered as an asset with an estimated future value, categorized by sex and apparent health. The entry for Della's first child read, "Male infant, sound, estimated value at working age $400 to $600 depending on market." Josephine made the report because she was required to. She did not look at Thibodeau when she gave it. The first observable tension arrived not through a dramatic event, but through an administrative one. In late 1838, Prosper Lemaire's children from the property, both under the age of 6, both born to women in the field gang. The sales were conducted without prior notice to the mothers. One woman, named Cecile, was returned to field work the following morning. She completed her assignment. She did not speak for 3 days afterward, which Thibaudot noted in his incidents column as sullen, observed. Della witnessed the transaction from the processing house doorway. She was holding her infant son. She went back inside and did not come to the doorway again that day. Through 1839 and 1840, Della's son remained on the property. He was healthy and was noted twice in Lemaire's asset ledger with upward value revisions. Della continued in the processing house. Thibaudot's register showed consistent output, with no incidents. On the surface, the record of those 2 years was unremarkable. What the record did not capture was the structure of surveillance that governed every interaction between enslaved mothers and their children on the property. Visits to the children's quarters were permitted only at designated times. Extended physical contact during working hours was considered an efficiency loss and was subject to correction. Josephine managed the children's quarters and maintained a separate informal log of her own, not written, but memorized, of which mothers were being watched most closely and why. In 1841, Della became pregnant for the 2nd time. The father was not identified in any document. Louisiana slave law did not paternal identification for birth registration purposes. Thibaudot noted the pregnancy in his register in the 5th month. As was his practice, early notation was considered prior given infant mortality rates. The second child, a girl, in February 1822. She was recorded in Lemaire's asset ledger. She was dead within 3 weeks. Thibaudot's register noted, "Tente, cause unknown, Josephine attended." Josephine reported the death as a respiratory failure. It was not investigated. Infant mortality on Louisiana sugar plantations during this period ran between 25 and 40% in the first year of life. A single unexplained infant death was not anomalous. Della returned to full work rotation 6 days after the death. Thibaudot noted her return without comment. Who had attended the child in its final hours, said nothing to Thibaudot and nothing to Lemaire. What she understood or suspected in 1842 is noted anywhere. What is recorded is that she continued to assist at every subsequent birth Della experienced, and that her reports to Thibaudot after each one were consistent. Healthy delivery, cause of subsequent death listed as natural. In 1843, Prosper Lemaire refinanced the plantation's operating debt through a New Orleans lending house, using his enslaved population as collateral. The collateral assessment required a full inventory of human assets, including projected reproductive output. Della was listed by name, age, and reproductive history. 2 live births, 1 surviving child, 1 infant death. Her estimated productive value, including potential additional, was calculated and entered it into the collateral document. This assessment was filed with the parish. It was a routine financial transaction. What it established, in legal terms, was Della's body and its biological output were formal instruments of debt security. Her children, born and unborn, were line items in a lending agreement. By 1844, the pattern had become procedural. Della had delivered 4 children. 3 were dead. 1, her firstborn son, now 6 years old, and regularly assessed in Lemaire. The deaths had each been attributed to natural causes by Josephine. Thibaudot had noted them without escalation. The plantation's infant mortality rate, while on the higher end, was outside the range that would trigger external inquiry. What had changed was not the record, the texture of daily life around Della. Josephine began sleeping in the children's quarters more nights than not. She did not explain this change to anyone. Cécile, whose own children had been sold in 1838, began trading work assignments with other women to remain closer to Della during the hours after a birth. These were small adjustments. They did not appear in any document. The first irreversible step, the moment that, in retrospect, defined everything that followed, came in late 1844, when Lemaire informed Thibaudot that he intended to sell Della's surviving son the following spring. The boy was 7. The market for healthy male children in that age range was strong. Thibaudot entered the planned transaction in a forward-dated column of his register. Della was not informed directly. She learned it the way all such information traveled on the property, through the movement of other people, the particular silences of those who knew, and the way Josephine looked at her the morning after the decision was made. The son was sold in March 1845 to a buyer from Baton Rouge. The transaction was completed in the front yard of the main house, in the presence of Thibaudot and 2 field supervisors. Della was in the processing house at the time. She was not brought out. The boy was 7 years old. He was placed in a wagon. The wagon left. Thibaudot recorded the sale price, $4, in the asset ledger and noted the reduction in inventory. Della's name did not appear in his register that day. She completed her shift. She was present at the evening count. She did not speak. What followed over the next 8 years was not visible in the official record as a pattern. It was visible only in aggregate. A series of infant deaths on a single property, each attended by the same midwife, each attributed to natural causes, each involving the same mother, between 145 and 153. Della delivered 7 more children. All 7 died within their first month of life. Josephine reported each death. Thibaudot recorded each one. Lemaire noted the depreciation of projected asset value in his ledger. No single death triggered investigation. The cumulative record was available to anyone who read the full ledger consecutively. No one did. Entry was processed in isolation as administrative fact. The aggressive action came not from within the plantation, but from outside it. In 1853, a physician named Dr. Fontenot was contracted by Lemaire to conduct a general health assessment of the enslaved population, following an outbreak of fever that had reduced the field workforce. Fontenot reviewed Thibaudot's register and Lemaire's asset ledger as part of his assessment. He was the first person in 15 years to read both documents together, sequentially, against each other. He identified the pattern within 2 hours. He brought it to Lemaire the same afternoon. Lemaire's response was not immediate outrage. It was financial. He calculated the asset losses represented by 11 infant deaths and compared them against the cost of legal proceedings. He consulted a lawyer in New Orleans named Gaston Remy, who reviewed the situation and identified the structural legal problem immediately. The children were property. Harming property, even destroying it, was not homicide under Louisiana law. It was destruction of assets. The charge available was not murder. It was property damage against the owner. Lemaire was, in the eyes of the law, the primary injured party. Della was brought before Lemaire, Thibaudot, and Remy in the main house. She was not asked whether she had done it. Remy had advised against asking directly. on the grounds that a denial would complicate the proceedings. She was told what was known, what was documented, and what the legal consequence. She did not deny it. She did not speak at all during the meeting. Thibodeau noted in his register. Della questioned, no response. This was the last entry that mentioned her by name before the trial. Her 12th child had been born 4 months earlier, in early 853. The child was alive. Josephine had attended the birth. Whether Della had intended to act and had not yet done, or whether something had shifted in the 18th year of her decision-making, is not answerable from the surviving record. The child was alive. That fact in the legal proceedings, the most complicated one. The trial was held in the parish courthouse in late 1853. The charge, as Remy had structured it, was willful destruction of property, specifically the deliberate killing of 11 enslaved infants belonging to Prosper Lemaire, with a combined assessed value of approximately $1,200 at projected working age. The prosecution presented Fontenot's analysis, Thibodeau's register, and Lemaire's asset ledger. The pattern was clear and the documentation was thorough. The defense had no counter-evidence. Josephine was called as a witness. She confirmed that she had attended each birth and each death. She confirmed that she had reported each death as natural. She was asked whether she had known the deaths were not natural. She said she had not known. The court accepted her answer. She was not charged. The structural problem Remy had identified became fully visible during the proceedings. The prosecuting attorney was required to argue the destruction of property, while simultaneously treating the deaths as morally significant. Because without moral weight, the jury would not convict, but acknowledging moral weight meant acknowledging that the infants had been persons, not property, which directly contradicted the legal framework under which the charge had been filed. The prosecution attempted to hold both positions simultaneously. The defense attorney, a man named Berard who had been appointed by the court, argued that the charge was internally incoherent. Either the children were property, in which case the question of intent was a civil matter between Della Lemaire, or they were persons, in which case the charge was wrong. The court did not resolve this argument. It proceeded to verdict without resolving it. Della was convicted. The charge was recorded as willful destruction of property, aggravated by pattern and premeditation. She was sentenced to hard labor for life, to be served at the state penitentiary in Baton Rouge. She was transported within the week. Lemaire received a partial civil settlement from the proceedings, a nominal acknowledgement of his asset losses, paid from a fund that did not cover a fraction of the calculated value. He sold the remainder of his enslaved population the following year, and leased the land to a neighboring planter. The 12th child, the surviving infant, was sold at the same time as the rest of the population. The buyer was not recorded by name in the surviving documents. The child's sex is listed in the sale record. The child's name is not listed. Della had named this child, as she had named all the others, in a language no document recorded and no court had asked about. Josephine was sold to a buyer in New Orleans. She was approximately 80 years old at the time of the sale. She does not appear in any subsequent record. The trial record was filed with the parish court and remained accessible in the public archive. It was referenced in at least 2 subsequent Louisiana legal cases involving the destruction of enslaved property, cited it as precedent for the principle deliberate killing of an enslaved person by another enslaved person could be prosecuted as property damage, even in the absence of a homicide charge. The cases that cited it were concerned with legal procedure, not with Della's circumstances. Her name appeared in those citations as a case number. Della arrived at the Louisiana State Penitentiary in Baton Rouge in late 1853. The prison's intake record listed her name, age, approximately 34, assigned labor category, and the nature of her conviction. She was assigned to textile work. Her name appears in the prison logs through 856. After that year, her name does not appear in any surviving record. The prison's mortality records for that period are incomplete. Whether she died in custody, was transferred, or was subject to a record gap cannot be established from available documents. What the official record preserved was the charge, the conviction, the sentence, and the asset valuation. What it did not preserve was any testimony from Della herself, not because she refused to testify, but because she was not asked. Louisiana court procedure in slave cases did not require the defendant's account. Physical and documented evidence was sufficient for conviction. She was present at the proceedings. She was not invited to speak. No transcript of any statement she made voluntarily exists in the archive. The legal question Behard had raised during the trial, whether the children were property or persons, and what the implied about the charge, was never formally answered by the court. The judge's written ruling addressed the sufficiency of the evidence, the appropriateness of the sentence. It did not address the underlying classification problem. The ruling was 8 pages long. The word person did not appear in it. Cecile, whose children had been sold in 838, and who had adjusted her work schedule to remain near Della after each birth, was sold with the rest of the Lemaire population in 1854. Her destination is not recorded. The 12th child grew up without a name in any official document. The sale record listed a sex and a price, whatever Della had called that child, in the same private language she had used for the 11 who did not survive, when recorded and was not asked for. The child was purchased, assigned a name by the buyer, and entered into a new property ledger. 11 deaths had been prosecuted as asset destruction. 1 survival had been sold as an asset. Court had processed both outcomes correctly, according to the law as written. Whether the law had processed them justly a question the archive raises, with answering, and leaves, without resolution, to the reader.